As we approach December, it's a time for reflection. But besides that, we have a few scheduled court appearances. We have some. So December 1, I am back on trial, an in-person trial in a divorce matter. I've been on this case for 5 years. This is the case that I have been on trial 6 days already since August of 2021. And then later in the month, and I have other things scheduled, just wanted to highlight two things. The fact that the in-person trial, mask on, is going forward. And then mid-month, I have an interesting proceeding. It's a proceeding that I've never actually been a part of prior to this. I represent an individual where we're not probating. Sorry. The client came to me to probate a will. Client only had a copy of the will. We could not locate an original will. So instead, we're doing an administration of the estate. The copy of the will cannot be probated. So the proceeding is that a beneficiary under the will is asking for me to be examined under oath, because the assertion is, from this person, is that I have the original will. I was not the attorney draftsman. I never had the original will. My client never had the original will. So I guess there'll be questions like, do you have the original will? I'll say no. Have you ever had the original will? I'll say no. Did you draft the will? I'll say no. Did there come a time that you ever had possession of the will? I'll say no. Maybe it'd be a little bit more than that, but there's an awful lot I don't know. I don't know where the original will is. So that's the type of proceeding. It makes sense to ask. And really, right, because someone could potentially get a will that they're not a beneficiary under and rip it up, destroy it. Committing a fraud, it's a crime, right? They destroying someone else's will. But maybe, the adult child doesn't want to have the stepmother receive anything, or maybe the half sibling. I can envision a few terrible scenarios, but in this instance, I never had the original will. So, see you soon. FrankBrunoLaw.com.